during misdemeanor docket code, open court is open court. Can you make an objection like, we should be able to see all these terrible plea offers that our people are defending or taking. All right, recent case law. If any of you are interested, SCOTUS blog is an awesome blog. I highly recommend it. I read it probably almost every day. They always have the pending cases. They have a little information about it. And there's our good Thurgood Marshall of that after Brown versus Board of Education, which if you didn't know, there's a museum to that. All right, here's our illustrious court. You can log on. What day do they decide every case? Wednesday. Every Wednesday, the court comes down with some new hate-filled opinions for you to kind of deal with. Oh, I'm sorry. I actually have some good ones to talk about. Very few, but a few. All right, we're just going to zip through. All of this is in the paper, and in the paper, I give you the site. I bring the case down to one line, and then I give you a quote from the case, so you sort of get the feel, the good, the bad, the ugly. If any of you do appellate work, Anders briefs. They have new rules that the defendant has to have the record. I mean, what a stark idea, but it's a question of whose responsibility it is. And I think the Court of Criminal Appeals is saying that it's the defendant's, you have to let the defendant know to write to the Court of Appeals to get the record. I've now started, since everything's on CD-ROM, I print it out and just mail it to them right away. Here it is. I try not to do an Anders brief, but either way, they've got the record.
Do you actually do a hard copy, or do you send them a disc?
I can't send them a disc in the prison, so I send them a hard copy.
I didn't know if they had computers in their law library.
No, I don't think so, but what I do is I print like 2 pages on each side, so it's actually 4 pages of the record on one sheet of paper, so it's less cumbersome, and most records aren't that long. I love this. A district clerk must tell an indigent defendant what the cost of its transcript would be. The defendant kept writing, I want to buy it, what will it cost, and they wouldn't answer him. So he did a mandamus, boom, got his answer. And that's where he couldn't afford it. No, just kidding. All right. Competency. So they take the defendant or the child witness in the back, and the judge questions it without the lawyer being present. Is that a critical stage of the proceeding? The court says no. But I want you to know there was no objection. So a lot of this is, at your own peril. Okay, in this case, the court actually found ineffective assistance when the defense failed to get an expert on, and I'm sorry, that intoxication-induced incapacity. Thank you. So that tells us, and Judge Kinney was talking about asking for ex parte funds. It's incumbent on the attorney to ask for that money, and if you don't ask for it, and then they don't give it to you, then you might be ineffective. If you ask for it and they don't give it to you, then they're ineffective. Who do we want ineffective? Judge, not me. Right to counsel. This is an interesting case. He's charged in Ector County with some sex offense. Well, Midland County has the complaining witness call up the defendant and get some bad statements from him, and then Ector County tries to use those statements. They're like, no, he already had counsel in Ector County. You can't try and subvert it by having another agency from another county get bad information. Don't worry, they can use it in Midland, so he's still going down the court. Okay, well, you just can't use it. All right, deaf interpreter necessary. So the lawyer was ineffective for not requesting an interpreter, right? That seems pretty easy, right? Yeah. See, that would never happen here. This is probably Lamar County. I'm kidding. All right. Ex parte bill, the judge tried to say, well, the 90 days under 17.151 doesn't apply because he's a danger. And for safety concerns, we don't have to follow the law. Of course, actually, it means what it says. It's that statutory interpretation we learned in law school. All right, someone was talking about bonds. If you want to lower the bond and you file a motion, you can't appeal that. File a writ. A writ. A writ. You can ask for expedited ruling, and they're pretty quick on that. I would say, you know, the briefing schedule is truncated, so it shouldn't take as long. But if you file the motion, you're never gonna get it. That's my, that's us when we do the writ. Take that, Judge. All right. Oh, and I should mention, when they're talking about judges, I gave this same presentation to the judges conference this summer. Not all of them attended, and I was a little bit more serious about slamming the court, but all of them attended. So, or not all of them, the ones that did attend, I think, took advantage. And so I do have a lot of capital stuff on there because I know these courts hear it. Okay, this is the standard for incompetency to be executed is a substantial showing, which is more than some, but less than a preponderance. You know, so we just want to make sure you kind of know we're going to kill you. Right. Small, you're like a serial killer. Right? Defendant has an idea. Okay, let's get the needle. All right. Execution, IQ 70 used to be the magic number, right? Oh, well, he's got an IQ above 70, we can kill him. It's not the magic number anymore. And for those of you who have ever done mental retardation or capital work, those numbers are really meaningless. It's their adaptive behavior, it's a whole bunch of other things, but they want, you know, they love that bright line. Like, oh, some incompetent teacher gave him an IQ test in 3rd grade, and he got 71. We can kill him. Not anymore. Not anymore. They gotta work a little harder. Okay, newly discovered evidence to support mental retardation claim can entitle an applicant to relief. This case is awesome because years and years ago, the defense attorneys got subpoenaed TDCJ and said, look, we need to see all these records. Anyone here ever work at TDCJ? Yeah. Let me tell you, TDCJ's like, yeah, we got nothing. 20 years later, they find all this stuff about his mental retardation that the TDCJ never turned over. The court said, well, you know, this is bad, but it's not really the defendant's fault, so we'll let you bring the new evidence in. Even though TDCJ had a long time. And now, TDCJ is going to start putting all their files, like, digitized. And that scares me. So I don't trust them. All right, moving right on. Charging instrument. This, again, I'm going to say it was okay, and there were 11 separate chart paragraphs. Or was it paragraphs or counts, 11 counts. They deleted 5 and they renumbered them. And the court said that was okay. But again, I'm going to tell you, the lawyer made no objection. So while you can say, if they start renumbering things in your case, well, I think I remember some case and it's okay. It was only okay because the lawyer didn't object. So remember that. If you don't know what to do, object. It's a little longer. Object. And if you're not sure of what basis, due process. Yeah, it's a violation of my due process. And I kid you not, you will preserve so much, like, me and Mr. Appellate Attorney would love it. I saw that. Length of time controls for community supervision. This is awesome. The guy kept kind of having some issues, so he had like a year, and then they brought him back and they gave him another 6 months. Well, they gave him like 1 year, and so they did like April 4th to May 4th, and they added like 180 days, so they just added 6 months. Well, that was actually 1 day too long, so the state filed their motion to revoke his probation 1 day after it had concluded because of the counting of the days. So, it's the number of days, not the term. Anonymous tip. I mean, this was a Supreme Court case. Someone called up, yeah, some drunk driver tried to run me off the road. Is that sufficient to pull someone over? Yes. Because it seemed very reliable. Very reliable. They called up and said, someone tried to run off the road. You know, not like your ex-husband would ever try and get you in trouble or anything. Okay. One subject. This is about punishment for evading arrest. And I don't know if you all remember how they changed the punishment, and they attacked it in a pretrial writ habeas corpus because they said it violated the one subject rule. Do you all know what the one subject rule is? one subject. So you can't put in a lot of things there that don't belong to try and hide them. But the court said, oh, that's fine, that's very close enough. Don't worry, he's still going down.
That it is a third-degree felony now.
Right. Okay for juvenile offenders to not have a individualized sentencing and get life as long as they're eligible for parole after 40 years. And I'll tell you, there were 3 or 4 cert petitions from Texas pending on whether that was constitutional, and we all lost 2 days ago. So it's okay for now. But don't think I'm giving up. I'll still be fighting. All right, cross-examination. You can't go into the pending charge, like, oh, you've been charged with this, but you can go into the term of years. And I love when the court uses the language, they say, well, the witness might try to mollify the state so they don't get as many years. That's a good word. So that is an appropriate area of inquiry if you're facing pending charges. You know, you're facing life imprisonment, aren't you? So you're more likely to lie. I'm just kidding. Once the jury's been sworn, even if the state wholly fails to participate, jeopardy has attached and acquittals cannot be considered on appeal. Now, why that's even a Supreme Court case, like, doesn't that seem, I mean, really, that'd go all the way up for them to say, yeah, boom, you're out of luck, state. You don't want to play? Now you will. All right. Unit of prosecution in a robbery case is each individual who could be subject to the assaultive conduct. So you can't use the same person and they want to get an aggravated robbery by causing bodily injury and aggravated robbery by threat of the same person. It's got to be different people. That's the unit of prosecution. All right? I don't even know if DNA even matters anymore. It hasn't all been tested, but they've been big on Chapter 64. If you all, anyone who's done capital work, swearingen's been around forever. I swear, as long as I worked at the prison 20-some years ago. Law of the case and overwhelming evidence defeat his motion for DNA testing. Because they're like, look, even if the DNA came out to be the railroad killer, we don't care. You're going down. Really? Defendant must show he would not have been convicted if the DNA was found on a particular item. There, of course, is Michael Morton, which we know the state's theory was, well, so what if his DNA isn't on the bandana? We still got him. Right. DNA motion review. The intermediate courts of appeals can consider appeals of Chapter 64 motions, possibly only unfavorable findings. Kind of an odd thing, these appeals of Chapter 64, and the left has tried to fix it and make it easier for inmates to get DNA, but they keep thwarting the ledge, our very liberal ledge. Okay, this is how many of you have ever had a case with a foreign document? I never have. But it went all the way to the Court of Criminal Appeals, and the state had some foreign document, but they didn't have all the certifications that the rule said they needed. And the court said, well, number one, you needed it. Number two, you didn't show a good reason why you didn't have it, so it doesn't come in. So that's a good little arrow in our quiver. Failure to dispose of evidence by the state is error reviewed under an abuse of discretion standard. Francis v. State, oh, Craig laughed, he's like, I don't want to hear about that. That's Craig's case. And the state the state, like the day of trial, was charged with like a knife and they showed with a machete. And he's like, whoa, that's not right. And I love this because the Court of Appeals was like, or the Court of Criminal Appeals was like, you know, the defense did such a good job with cross-examining everyone, there was no harm. They'll find some way. All right, guns and condos. I love this. Because the guy's walking around with his gun in the condo common area. They want to arrest him. But they actually had to look at the deed to the condo and see, well, that's like owned by everyone jointly, so that's like his residence to walk around with his gun. It's like open carry on his own home. But, you know, it's like now are the cops going to say, could I see your condo restrictions, or arrest you and tase you. All right. This case is from Galveston. Judge Chris was the trial attorney. I don't know who the defense attorney was. But what happened was the judge decided the evidence was hidden. Oh, it was a Brady violation. And so she dismissed the case. Well, then the defendant sought an expunction, and he got an expunction. Then the state bar wanted to prosecute the prosecutor, and his defense was, well, there's no records because they've all been expunged. How can I defend myself? They're like, no, we're not going to go there. But this is what I find really funny, and only like an appellate nerd like me would find this an inside joke. I like to read what the prosecutors write on their website about every case, because they always have like some crazy like, oh, don't worry, he's still going down, I swear. But they never put this case on their website. I don't know why. Not sure. So that's what they didn't have to put it on there. He's no longer one of those so bad apples out there. All right. If it hurts, it's coming in. All right. Testify to stuff that's not in their report and not in their protocol for testing. It's okay, because it's reliable. It was about trace cocaine, and they even got them on cross. Well, that isn't part of your protocol for your report, is it? No, I'm just letting you know that we found a little bit of cocaine. Really? Yeah, thank you. Thank you. I don't need any more gifts from you at all. All right. You know, this actual innocence, it's really troublesome for the court. It really is. They hate innocent people because, like, then they gotta try and be fair. And we're all here to innocent people. Anyone else are going out? But you have to prove it by clear and convincing evidence. And this, I did give this speech this summer, and this is that guy that was in prison, and he hadn't even asked for like a DNA test, and some DNA testing showed that he was innocent, so he was just doing his time. He was like, had given up, and he got free. So, you know, was it clear and convincing enough? Apparently, for this poor guy. All right, oh, there's our little Mark Bennett. Online solicitation of a minor. You know that dirty, sexy talk? Okay. Don't act upon it. Ex parte low, unanimous decision. If you haven't read it, Mark Bennett deserves great kudos. It's a great First Amendment case, but so many people are being freed by it. I mean, so often, like, we do a case and we help one person. He did this case and helped Mr. Lowe, but we had a case Amalia, our fellow, worked on where the guy went on a bus home to Iowa last week. I mean, there's nothing more moving than seeing the good work you do help so many people. So I really read this case, and it's a lot of fun. Oh, and the land gap of ex parte low, Mark got two statutes found unconstitutional. And the state tried to intervene, or the attorney general, and said, well, we didn't know that he was attacking a statute, which there's some weird provision in the government code. You have to notify the AG when you're attacking the constitutionality of the statute. And the court said, no, that violates separation of powers. And it was great because Judge Keller wrote a concurring opinion. And she goes, well, you can look online like everyone else does, Mr. Greg Abbott. Oh, yeah. I'm not even kidding on that. It's great. I mean, two for the price of one. I love it. Ex parte Thompson, improper photography statute, facially unconstitutional on First Amendment grounds. That is a crazy statute. If I take you a picture without your consent, and then I'm sexually gratified by it, I've just committed a crime. And now I can't be arrested, and that was not a confession. But my husband lives in Austin, and I read this in the Austin paper. This man walked into a Randall's, and he started taking pictures of this lady. I'm not saying that's right, it's kind of creepy, but what a normal woman would do is say, hey, cut it out, or leave, or whatever. She calls her boyfriend, who's a cop, and he comes and they arrest him, and allegedly he confesses to masturbating in his truck after he took the picture. I was like, really? But apparently now that's okay. Once the statute was held unconstitutional, actual innocence may be raised in a writ. Not sure what they're gonna do with these, online solicitation cases, because why would the court not wanna find them actually innocent? Money. They have to pay them. And if you ever have any question what anyone's motivation is, it's always money. Always. That's my theory, and it's served me well. Okay, but like if your client possesses what he thought were drugs and the lab says it's not drugs, he's not actually innocent. Because, it was like an attempt to possess drugs. But what if, I don't know. But anyway, George said, we're not giving him jack. This is the case I was mentioning about the latches. Latches is an equitable doctrine that says, now the state's harmed. But what makes me mad about Ex parte Smith is this is for an out-of-time appeal that the state agreed to, and the judge signed findings for the defendant to get his out-of-time appeal. The Court of Appeals, on their own, orders them to brief latches. And the defendant's attorney had a really great theory. He said, look, we've already made this agreement. You're interfering with the process here because you don't know what we may have given up or what we didn't. And the court's like, no, it's too late. And you know why they're doing that? Because they think they work too hard. How can we stop these flow of writs? I heard the other day one of the judges who will be nameless, Harvey, said, can we stop all these ineffective lawyers? And I thought, you never made him ineffective. So what are you talking about? They're all free. Waiver. So this guy files a motion to suppress and then pleads guilty, but in his plea he agrees to waive his appeal. Right. And he's like, well, I didn't mean that. I meant, like, I'm just waiving that, but I want to raise this. And they're like, no, you waived it, dude. So just be careful what you're waiving. Like Judge Guinea was talking about the judgment. When I worked at TDC, we'd see a lot of problems with jail time credit. They'd be like, oh, I didn't get my credit. And there's just some things to be aware of. Oh my gosh, I was all excited for this, but now I'm not. So it's very sad because I read today this was argued. The Supreme Court was going to hear some sort of challenge to 606B, which is the greatest travesty for post-conviction lawyers ever. Like whatever happens in the jury room, we can't hear about it. The juror lied during voir dire. Said, she had no bias. Then in the jury room, she's like, well, my daughter was sued as a truck driver because this was a truck driver motorcycle accident, and it was terrible, and she didn't do anything wrong. And of course, then later the jury finds for truck driver, amazingly. And so they got all the way to the U.S. Supreme Court to whether, when someone lies and then you find out about it in the jury room, can that be used in a motion for new trial? In the New York Times today, it said the argument was so one-sided that they're never going to rule against it. They didn't ask the government any questions, hardly, and the argument ended early, which is like, never happens. So, I don't know, that Adam Liptak in the New York Times didn't give me very good news today. So, I don't know what's going to happen with that. But 606B, what happens in the jury room stays in the jury room, for now. And that's the case, Warger versus Showers. And that's the other thing, if you look on SCOTUS law, it'll tell you what's been granted. Jury charge. Okay, if you do a lot of these sex crime cases, there's all these, like he did this with that and this and that. There's a real problem with unanimity, and the court's been very, I think, loose on it. It's like, well, it's okay if, you believe it was him, and, it was one of these victims over here because he did something wrong. So, in this case, of course, the state won, but there was some admonitions. You need to be aware of what they're charged with, what's in the application paragraph, but we know that unanimity is pretty much dead on those sort of stuff, on that sort of stuff. Self-defense instruction. In this case, the only self-defense instruction he would have been entitled to was aggravated, that he could use aggravated or self-defense because it was a deadly weapon, aggravated assault with a deadly weapon. And they were like, well, but you didn't preserve error properly. This one actually, the court said, yeah, you did. You're probably still going to lose, but yeah, you did. Oh, I'm sorry, they're going to remand it for reconsideration. All right, this was interesting. The guy had a credit card skimmer. And he said, yeah, I was just holding it for a friend. I didn't know it had credit card numbers on it or anything, and they're like, you're not entitled to voluntary possession when he claims he did not know the forbidden nature of the thing he possessed. It's kind of bogus, because if I had to like Google what a skimmer looks like, I don't know that that was that bad. Hey, can you hold my little metal thing with the magnet between it? Oh, now has she committed a crime? All right. Oh, this was awesome. You know, this case came out earlier this year, and the lawyer wanted to use the stair-step chart, and the Court of Criminal Appeals said, well, you know, it wasn't error, or it was error, but it was harmless. Well, right after that, I heard that Judge Patrick was up there saying, well, it's error to let him use the stair-step chart. So when I spoke to the judge, and I made sure to say, it is error to not allow it. Now, in this case, it was harmless, but it's error not to allow it. So make sure they know it's error, because trial judges do not get to make, you know, oh, well, I find it harmless. Harmless error is supposed to be for the appellate court to review inadvertent errors by the trial judges, right? Not when the judge knows it's wrong and just does it. Well, I think it's harmless. No, that should never come from a trial judge. They shouldn't even be thinking it. All right. Lesser included offenses. Criminal trespass is not a lesser included offense of burglary in every case. And so often people will just, oh, well, this is a lesser. You really need to look at what the elements are of the greater, make sure it all fits under with the lesser. Reformation of burden.